Have you ever wondered about the quiet, persistent battles fought behind the scenes, far from the daily headlines?
Hmm.
Today, we're diving deep into one such ongoing story. A decade-long legal struggle involving frontline health workers in India.
That's right. We're examining a really compelling legal saga unfolding in India's High Court in Uttar Pradesh.
Right.
It's a powerful illustration, I think, of how large-scale government programs, even those with, noble intentions, can profoundly impact individuals over the long term.
And how that brings complex human and policy questions right into the courtroom.
Exactly.
Our source material for this deep dive isn't a single report, but a stack of actual court documents, rulings, and orders from Uttar Pradesh spanning from 2014 right up to, basically the present day in 2025.
And these aren't just dry legal texts, are they? They're like snapshots of a prolonged fight for what's right.
Precisely. So, our mission today is to unpack the core dispute, trace the legal journey of these health workers, and maybe understand the broader implications for contractual employment in, vital public services.
Sounds good.
To begin, let's set the stage a bit. Who exactly are these health workers, and what national program were they a part of?
Okay. At its core, we're looking at the National Rural Health Mission, or NRHM. Many of you might recall it as a pivotal public health initiative launched by the government of India some time back.
Right, NRHM. Got it.
Specifically, our focus is on multipurpose health workers,
Yeah.
MPHWs, primarily males. Their essential role was combating vector-borne diseases, things like malaria, filaria, kala-azar, Japanese encephalitis.
So, major public health concerns, especially across Uttar Pradesh.
Exactly. Diseases that were, and frankly still are, major issues there.
So, how were these workers actually brought into the program? What were the terms of their engagement like officially?
Well, the guidelines for multipurpose health worker, male 2010, were actually quite explicit on this. Clause 3.1 stated that the central government would provide financial assistance for these contractual MPHWs for an initial period of 3 years. That 3-year part is key.
3 years, right. And where were they working?
They were to be strategically placed at over 53,000 primary health centers in 235 high-focus districts, and the pay was set at R6,000 per MPHW per month.
Okay, 6,000 rupees. And how was that financial support structured? Was it all coming from the central government for those 3 years?
Not entirely, no.
Yeah.
The expenditure was actually on a sharing basis between the central government and the state governments.
Okay.
There's a letter from January 3, 2011 that detailed this. It started with the central NRHM covering 85% and the state governments covering 15% for the first year.
And then it shifted.
Yes, gradually. It moved to 75%, 25% for the second year, and then 65%, 65% for the third year. So the state's share increased over time.
That seems like a clear financial roadmap for that initial phase, that 3-year phase. But beyond those 3 years, was there a long-term plan for these? I mean, these crucial workers?
Yes, and that's where it gets particularly significant legally speaking. Clause 3.3 of those same 2010 guidelines laid out a critical expectation.
Which was?
State governments were required to create the necessary regular posts and fill them within those initial 3 years.
So permanent jobs.
That was the clear intent, yes. To ensure the continuity of these MPHWs after the central government's financial assistance ended, the center was basically providing a runway, a temporary boost.
With the expectation that the state would take over and absorb these roles permanently.
Precisely. That was the design.
And when did Uttar Pradesh actually, kick off this scheme and start appointing these workers on the ground?
The program commenced in Uttar Pradesh in 2012. The mission director of NRHM in UP issued directives in September 2012 for appointments.
Okay, 2012.
And most of the individuals involved in these court cases, the petitioners, they were appointed between October 2012 and March 2013.
Right. So doing the math, if the original guidelines were followed, their 3-year term should have run until, late 2015 to early 2016?
Correct. That would have been the expectation based on the initial guidelines and their appointment dates.
So everything seems structured, a clear 3-year plan with this eye towards regularization. But then, unexpectedly it seems, something shifted. What happened that abruptly changed course and led these workers to, seek legal recourse?
Yeah, the major turning point, the real trigger, came with a circular. It was from the mission director of NRHM UP, dated February 26, 2014.
Okay, February 2014. What did it say?
This circular explicitly prohibited the extension of these MPHWs beyond March 31st, 2014.
Wow. Okay, so much earlier than their 3 years were up.
Much earlier. And this decision actually followed an earlier communication from the central NRHM, the government of India level, back in November 2013.
What did that one say?
That had already stated the central government support, the funding, for contractual MPHWs would cease after March 31st, 2014. No more central money after that financial year.
So hang on. Despite their initial understanding of a 3-year job, these workers were suddenly facing discontinuation within, what, maybe a year or two of starting.
That's exactly the situation they found themselves in. A very abrupt shift.
How did they respond? I imagine they didn't just accept it.
No, they didn't. They immediately took the matter to the High Court. One of the primary cases, writ petition, SS 1453 of 2014, titled Shiv Pratap Maurya and 667 others versus State of UP, became sort of central to this whole dispute, along with many connected petitions.
Okay, Shiv Pratap Maurya. And what were they arguing?
They challenged these circulars, naturally. They argued for the continuation of their work, at least until the scheme's intended end, for payment of their salaries and arrears, and ultimately for those regular appointments that were initially envisioned.
Makes sense. And what was the court's initial stance on this? Did they buy the workers' 3-year expectation argument?
Well, the court, in an interim order, so not a final decision, but an initial ruling dated March 25, 2014, took what's called a prima facie view. Essentially, a first impression, or on the face of its determination, and their prima facie view was that these petitioners were required to be engaged for that initial 3-year period, just as the guidelines said.
Ah, so they agreed with the workers on that point initially.
It appeared so. They directed that the workers be allowed to continue working beyond March 31st, 2014, with proper payment, provided, of course, their work remained satisfactory.
Okay. And that direction was reinforced later.
Yes, it was. In a similar case, Writ a No. 59726 of 2015, the court reiterated this stance in an order on October 16, 2015.
So the court seemed to be, trying to uphold the workers' original 3-year expectation. But did the government actually comply with these interim orders? Did they keep them on and pay them?
Well, not quite in the way the workers had hoped, or perhaps how the court intended. After that March 2014 interim order, the central government did extend their services, but only for a short period, until September 30, 2014.
Just a few months.
Right. And they explicitly stated that any costs beyond that date would have to be borne solely by the state government. The center was washing its hands of the funding.
And what did the state government do then?
This is crucial. On February 4, 2016, the state government issued a letter to all chief medical officers, the CMOs, in UP.
And this one said?
It explicitly stated that the scheme for these MPHWs had been closed, finished, and it directed CMOs not to take work from them anymore.
Wow.
It even went so far as to warn the CMOs that they would be held personally liable if they did continue to employ these workers.
That's a direct clash, isn't it? The court is saying keep working and pay them based on the interim orders, but the state is sending out official letters telling its officers to stop the work completely.
A complete contradiction that put everyone in a very difficult position.
So what was the reality on the ground for these workers then? Did they stop working in February 2016?
Well, this is a key part of their claim. Many petitioners stated they actually continued working until March 2018.
March 2018. That's 2 years after the state told the CMOs to stop employing them.
Exactly. Well beyond both the initial discontinuation date and the central government's extended period.
And the big issue here must be pay, right?
Absolutely.
Yeah.
They alleged they were not paid for this extended period of service from roughly late 2014 or early 2016 up to March 2018. They also claimed the court's interim orders weren't properly implemented, which led to contempt of court proceedings being filed.
So they kept working, possibly relying on the court's interim protection, but without getting paid for potentially years of work. What did the High Court ultimately have to say about this situation, this unpaid labor?
This is where a really important legal principle comes strongly into play, the concept of begar.
Begar.
Yes. It essentially means forced labor, particularly without payment. It's prohibited under the Indian Constitution.
Okay.
And the High Court, in its final judgment for that main Shiv Pratap Maurya case, which came much later on March 20, 2024, forcefully addressed this very point.
What did they rule?
They stated very clearly that if work was taken from the MPHWs up until March 2018, if they actually performed the duties, then the state was unequivocally liable to pay them for that entire period,
regardless of whether the scheme was officially closed.
regardless. The court specifically cited Article 23 of the Constitution, which prohibits forced labor, and read it together with Article 21, the fundamental right to life and livelihood.
So the constitutional right to be paid for work done trumps the administrative status of the scheme.
That's the core insight, yes.
Yeah.
The judgment basically says you can't benefit from someone's labor and then refuse to pay them by citing technicalities about a scheme ending. Non-payment for work done amounts to BAGAR.
That's a truly powerful legal affirmation for these workers after such a long time. What were the specific directions the court gave in that 2024 judgment?
Right. The court ordered both the central and state governments to ensure payment to the petitioners for their initial 3-year period, calculated from their individual appointment dates, and to do so within 2 months.
Okay, payment for the first 3 years. What about the period after that, up to March 2018?
For that period, beyond the initial 3 years, the state government was directed to pay the petitioners, right up until March 2018. However, this payment was subject to verification that they had actually worked during that time.
Verification makes sense. Was there any evidence they were still working?
Yes, and this was important. A letter surfaced, dated October 29, 2018, from the Director General, Family Welfare. It actually showed that 394 MPHWs were indeed still working at that point.
Even after the state claimed the scheme was closed years earlier.
Exactly. So that lent credibility to the petitioner's claims of continued service.
So even with this really significant ruling about getting paid for past work, the struggle wasn't entirely over, was it? Because there was still the issue of their long-term future, that original promise of regular appointments.
Precisely. The payment issue was one major battle, but the regularization question was another ongoing front.
How did that play out in court?
Well, in another key case, the Ankit Pathak case, the court started specifically inquiring about pathways to regular appointments. This was around April 11, 2022.
Okay.
The Special Secretary of UP responded to the court. They clarified that while multipurpose health worker isn't technically a cadre post in the state structure, health worker posts, both male and female, do exist.
Ah, so similar roles but different official designations.
Sort of. They informed the court that over 9,000 vacant female health worker posts had already been advertised back in 2020, and that selection process was ongoing.
What about the male health workers, the ones mostly involved here?
For the male health worker posts, they said amendments to the relevant service rules from 2018 were in progress. The plan was to advertise the vacant male posts within 2 months of those rules being amended, and then complete the selection within 6 months after that.
Okay, so a plan was forming, but it sounds like there was a potential catch with those new 2018 rules, something the workers were concerned about.
There was, yes, a significant one. The petitioner's lawyer raised the point that these 2018 rules required a specific 1-year training.
And these MPHWs hadn't done that training.
Many of them hadn't. No, they were hired under the old scheme. So this new requirement could potentially disqualify them, or at least be a major hurdle.
So what did the court do about that?
Recognizing this potential unfairness, the court, in its interim directions on April 12, 2022, ordered the government respondents to complete the amendment process for those 2018 service rules within 6 weeks.
And crucially,
The court specified that these amendments must take into account the benefit of the experience these petitioners had already gained over years of service, and they needed to assure the petitioners were considered eligible for whatever the prescribed training was.
so trying to bridge the gap between their past service and the new requirements.
Exactly. The selection process was then supposed to conclude within 4 months after the amended rules were finalized.
It really paints a picture of this continuous grinding process of legal pressure, nudging the bureaucracy forward step by step. And this whole situation, these cases like Ankit Pathak, they are still actively ongoing even now in mid-2025.
They absolutely are. The Ankit Pathak case, for instance, looking at the court records, has seen numerous adjournments through late 2024 and into early 2025.
Why the delays?
Various reasons cited in the order's counsel availability, changes in which judges are hearing the case, just general paucity of time on the court schedule.
Mm.
But a key thing is, most recently, on July 9, 2025, it was listed for its next hearing on July 16, 2025. So it remains a very live, active matter before the court.
And incredibly, we even found evidence in our sources of a brand new petition filed just this year, 2025, still challenging that initial 2014 circular from over a decade ago.
That's right, the Ved Prakash case, filed in 2025. It also challenged that February 26, 2014 circular, which first tried to stop their work.
What did the government argue about that? Surely they said it was too late.
They did. The respondents argued it was highly belated, filed way too late, and also infructuous, meaning pointless or irrelevant now because it applied to 2014, 2015.
But the court,
But the court, on April 23, 2025, ordered it to be connected and listed together with the ongoing Ankit Pathak case.
which suggests.
It really underscores how deeply rooted these issues are. Even though the original event was over 10 years ago, the court still sees the challenges relevant to the ongoing dispute about these workers' rights and future. It shows these issues continue to hold judicial importance.
What an incredible protracted journey for these multipurpose health workers. I mean, from signing on for what seemed like a vital role in a national health scheme to then finding themselves tangled in a decade-long legal battle
Yeah.
just to ensure basic things like continuity of employment and fundamentally fair pay for work actually done.
It really does bring into sharp focus the human element behind these large-scale government programs, doesn't it? And the often unforeseen, long-lasting consequences for the individuals involved.
Absolutely.
And I think this deep dive really shows the persistent challenges in trying to reconcile, the typically short-term funding cycles of many government schemes with the very real long-term public service needs on the ground.
And the courts seem to have consistently stepped in here.
They have in these instances. They've consistently upheld that fundamental principle, compensation for work done. And they've invoked constitutional protections against unpaid labor, even when the official paperwork said a scheme was closed or the funding had shifted.
Yeah, the case powerfully highlights the critical importance of, well, clear, robust, long-term planning for contractual roles, especially in essential services like public health.
It's not just about launching a program, is it?
No, it's about designing a just and sustainable pathway forward for the actual people, the individuals who are at its very heart making it happen.
Which perhaps raises an important question for you, our listener, to think about after this. Considering the insights from this deep dive into India's health workers' long struggle, what innovative mechanisms, perhaps, could governments and policymakers implement right from the outset, particularly when designing these large-scale initiatives that rely so heavily on contractual labor? What could be done proactively to ensure smoother transitions and fair outcomes for workers when a scheme's funding or structure inevitably changes down the line?
So that individuals aren't left fighting for years and years in court simply to be paid for their essential service.
Exactly. Something to mull over.